Los Angeles landlords, your text messages can lose you your eviction case before you ever even get to court. Text messages feel informal and harmless. They're fast, they're convenient, and they feel private. But in landlord-tenant law, text messages are treated as written evidence, just like emails or letters. Once there's a dispute, every text you've ever sent, even ones you forgot about, can be printed, blown up, and handed over to a judge. Here's what landlords don't realize. A landlord's own text message can be used to prove rent waivers, show acceptance of partial rent after issuance of notice, support claims of harassment or retaliation, and undermine a landlord's stated reason for eviction. In many cases, the landlord did nothing malicious. They were just trying to be flexible or responsive. But a single text message like "pay me when you can" or "we'll deal with it later" can allow a tenant's attorney to argue that rent wasn't actually due or that the landlord waived strict compliance. Even something that sounds reasonable, like "I'll give you a couple more days," can directly contradict a rent demand and weaken a non-payment case. Texts about repairs, habitability concerns, or frustrations with the tenant, especially when followed closely by an eviction notice, are often used to argue retaliation, particularly in the city of Los Angeles. When those texts come into evidence, judges don't treat them casually. They read them as intent, admissions, and credibility evidence. And once that happens, the judges may find your notice defective, question whether rent was actually due, delay the eviction for months, or dismiss the case entirely. Landlords assume texting is safer because it's informal. In reality, informal communication often creates more legal exposure, not less. If you wouldn't be comfortable reading your text out loud in court, don't send it. Before texting a tenant or filing an eviction, slow down and get legal guidance. A 2-second text can cost you months in court.